with a young, I think it was a 9-month-old or 8-month-old, sitting in the lap of the passenger in the front seat. All right, so you're Raphael Glover, and this is cause number 24 DCCR 0232. Mr. Glover's case was set for trial a couple of weeks ago. We were about to start with jury selection. Mr. Himmler filed a motion to quash the indictment based on some relatively new cases that have come down from the Fifth Circuit as well now from the Supreme Court with regard to underlying offenses on unlawful possession of a firearm by a felon. I have done a substantial amount of reading of those cases and reviewing all of that since the last court date. I know your position, obviously, Mr. Himmler, Mr. Nichols. What is the state's position?
Judge, after looking at those myself, I think we're in the Fifth Circuit case dealt with the underlying felony of being a simple possession of drugs. The Supreme Court ruling wasn't so much felon possession of firearm, but a firearm in the possession of a firearm by a drug user. So that was kind of the main theme under all those cases was simple possession, simple drug use does not equal dangerousness. In this instance, Mr. Glover's prior is for child endangerment. And while it is some years ago, on its face, that is reasonable to deduce that's a dangerous prior felony. He also has the intervening felon possession of a firearm in the years since that original conviction. So I think in this instance, the state can make a very clear argument that he's shown a history of dangerousness and that the prohibition on possessing a firearm by a felon should apply and the motion to quash should be denied.
All right, thank you. Anything else to follow up?
Other than just, I think the inquiry is dangerousness, and obviously drug cases are a subset of dangerousness, lack of dangerousness, but I don't think the ruling is limited simply to drug cases. I think the court's research probably reflects that. The question is whether the underlying felony conviction of endangering a child rises to that level of dangerousness so as to preclude his ownership of firearms or possession of firearms. I would just note that at the time he pled to that, there was no DWI child passenger statute. And I think had that statute been available, that's probably what he would have pled to. And then you obviously wouldn't have the endangering language and the conviction itself. So that is something that I would ask the court just to note that should the case just not to take notice of the fact that if the case were indicted today, it probably would not have been pled as an endangering child, DWI child passenger, and whether DWI child passenger cases are inherently dangerous, I guess, is another inquiry as well.
So there's nothing at this time in these newer line of cases that is specific with regard to any other real underlying type of offense other than possession of a controlled substance or possession of a drug of some sort. And I'm not going to start going down the road, I think, of making those decisions unless it is real clear, I think, for whatever reason that underlying offense should not be included. And so I am going to deny the motion to quash, and we will get this case set back on the trial docket as quickly as we possibly can.
I think it's currently, it has a trial.
Is it still already? Okay, it is. All right. And just also part of that finding that I'm making is based on the actual facts of the underlying case, regardless of whether or not it's an endangering a child or nowadays a driving while intoxicated with a child passenger. I would think regardless, it's the same, that the facts of this case as reviewed with a young, I think it was a 9-month-old or 8-month-old sitting in the lap of the passenger in the front seat of the car. I think that in and of itself is dangerous, whether it's a DWI or an endangering a child, either way. So that is the basis of my finding. So we will move forward with trial at that next court date.
Sure.
All right.
Thank you, Your Honor.
You can, you're free to go, sir. I don't have an order. If someone would prepare an order, please.
Yes.
Himmler, someone. And then you have Jacordian Guillory,
Yes.
2 cases.
Yeah.
Good morning. Are you Jacordi and Guillory?
Yes, ma'am.
And Mr. Guillory has two cases. 23 DCCR 1225 is a motion to revoke probation. Underlying offense is evading arrest or detention with the use of a vehicle. And then we've got 26 DCCR 0631, a new offense of evading arrest or detention with the use of a vehicle. And what is the announcement?
Your Honor, I've reviewed the discovery in this case and discussed it with Mr. Guillory. He's advised that he did not commit the new offense, although the state's conveyed what I consider to be a reasonable offer to dispose of the NTRP in the new case. Since Mr. Guillory is maintaining that he's innocent of the new charge, I have to set it for him.
So I would,
Absolutely not true.
so we want to go through the motion then and go forward on that motion instead of the, let me get that pulled up. And are there any videos or anything that you need some time to watch?
No, I don't think
before?
from reading the file, there were no videos that identify the defendant. Or actually identify the person operating the motor vehicle.
Oh, okay. All right. Give me just a second to get that pulled up.
I do have some media on that, Judge, and I'll make sure that Mr. Kimler, if he indicates to the court that he is retained on that case, I will make sure he has access to discovery, and I'll make a copy of that.
I've got them on both cases.
Okay.
So if you'll make that request, Mr. Kimler, it sounds like there might be something that,
And also, Judge, at the appropriate time, if I might just ask the court some questions regarding the bond issues, I'd appreciate that.
Mr. Guillory, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down, and will he waive the formal reading of the motion? All right, Mr. Guillory, in cause number 23, DCCR 1225, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 6th of 2025 for the offense of evading arrest or detention with the use of a vehicle, and that was a 4-year deferred probation. Is that correct?
Yes.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest or detention with the use of a vehicle, February 27th of 2026. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
Not true, because
It's okay. I'll get the explanations later. I just need to know true or not true.
yes, ma'am.
Count 3 alleges that you failed to remain in Jefferson County as ordered and that you were in Harris County, February 7th of 2026. And is that true or not true? Count 4 alleges that you failed to provide and maintain an accurate residence address with probation officer. It says you reported your address at 2218 Rush Street, but identified your address at 2450 West Lucas to the Beaumont Police. Is that true or not true?
It's not true because I had to change.
All right. Did you tell probation?
Yes, ma'am.
Okay. Count 5 alleges that you failed to provide documentation verifying the source and amount of your income, 2025 tax returns, etc. Is that true or not true?
That's true.
Count 6 alleges that you failed to provide verification of performing community service hours as required. Is that true or not true?
Not true.
Count 7 alleges that you were at a location other than your residence at approximately 11:20 p.m. on February 27th of 2026 in violation of your curfew. Is that true or not true?
This hearing just took an unexpected turn. Even after admitting to several probation violations, the judge isn't sending him straight to prison, not yet. Instead, she's holding off because the new felony charge is still being challenged. That decision could completely change the outcome of this case. So don't look away. The biggest ruling is still ahead.
February 27th of 2026.
It's not true.
Not true.
Okay. Count 8 alleges that you are behind in your court-assessed fees as of April 20th of 2026 in the amount of $1,812. Is that true or not true?
True.
All right. Did you enter your pleas of true to counts 3, 5, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 3, 5, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke the probation, but I'm not going to do that. I'm going to reset the case for a hearing, and any discovery or any issues with regard to that new case get taken care of before then. And Ms. Malfino, do you anticipate that being, I guess, just one officer?
One officer and Miss Lopez.
All right, so we can just do it at 11, don't y'all
Yes.
think? No, just on a regular court date, but at 11, giving us about an hour. Okay. All right, we'll see you back then, and we'll get an updated pre-sentence report as well. All right.
So,
We need a fingerprint over here, please. Oh, wait. Is there something else? I'm sorry.
No,
Come
I
back.
just was gonna let you know, I actually have one of those officers coming for a motion to suppress next week. I don't know if that will give Mr.
That's fine. You can do
time,
it.
but I'd be happy to do it. It's next Monday, the 13th at 1. We have a couple of those type of hearings.
That's fine.
I don't know that I can get an updated.
Okay, I just wanted to offer.
Okay,
Same officer would be here.
it would be okay as the 1 o'clock.
Started as routine legal arguments ended with two defendants facing very different futures. One failed to get his firearm charge dismissed, while the other avoided an immediate probation revocation, despite admitting multiple violations. But with another hearing on the calendar, this case is far from over.